docket, and we have some time constraints today, so we're going to be conscientious about time. Mr. McBroom, take it away.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of September 25th, 2024. I am Short-Term Rental Chief Bonnell McBroom III, and I'll be presenting the cases to the board today for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as to not disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board in their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined, not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted, if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on these cases before us today under provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that the majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order, appeal a finding of the board under the common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it is necessary for you to obtain the permit for which you have applied. It should be noted the permit must be obtained within 2 years for the board's approval to remain valid. I submit that all cases have been filed in proper order. The appellants have been notified by certified mail as required by the code, and all affected property owners have been notified, and the legal notification sign requirements have been met as required by the code. Chairman Caputo, before we move to the cases to be heard, we'd like to take this opportunity to recognize any elected officials that are in attendance. Are there any? Seeing none, we will have a rule change first on the docket today. That involves Rule 6C. It is simply a change of address. The meetings were stated in the rules to be held at 800 President Ronald Reagan Way, the Metro Office Building. when in fact it's normally held at the Howard Office Building, which is 700 President Ronald Reagan Way. Great.
I don't think this will be controversial. Shall I make a motion that we accept this rule change? I make a motion that we change the procedure rules, section C, from reading Metro Office Building at 800 President Ronald Reagan Way to the Howard Office Building at 700 President Ronald Reagan Way. Do I hear a second?
Second.
Can I see a show of hands? Who approves? Unanimous. All right, that rule change is made.
Thank you. Our first case on the agenda is 2024-011. Is the appellant present? That is 2523 Clifton Avenue. The appellant? Is there opposition present? Seeing none. You have a seat there.
So, Mac, just to, as you might recall, we discussed how there'd need to be a motion on a suspension of the rules to hear this case because of the unusual circumstances with the deferral.
Would you like to explain that to the chair?
I've got it.
Yep.
This case, you may remember, was slated for April of this year. We did not have a quorum for the April meeting and had to cancel, and this appellant had come in from out of state. We were rescheduled to hear it, as is normally the method. And unfortunately, the appellant's flight was canceled. So due to the unusual nature of this set of circumstances, we would like to suspend the rules to allow for the case to be heard today, despite the fact that there had been some roll-off of the appellant attending through no fault of her own, and somewhat through our fault. Does that sound okay with everyone? Okay, so I move that we suspend the rules on appellates automatically being denied relief and their case not being heard when they have not appeared for 2 meetings. Is that acceptable? That sound about right? Okay.
That's fine. So reference to Rule 4.
Oh, sorry, I'm referencing Rule number 4, Section B. Do I hear a second?
Second.
Can I see a show of hands? Okay, we've unanimously agreed to suspend the rules and hear this case.
And just a note, I believe that the representative for the appellant today will be the realtor, Miss Penny Tenpenny. Is that correct? Yes. All right. This is an MULA zone district, which allows not owner-occupied permits. And this is governed by BL 2020-187, which is a 1-year wait period for advertising and operating prior to obtaining a permit. And the board has discretion under BL 2023-136. On June 13th of 2019, the previous owners, Courtney and Jonathan Novak, obtained a multi-family not owner-occupied STRP permit. The permit was renewed in 2020, 21, and 22. When the permit was not renewed in 2023, the administrative assistant, Alicia Buffer, reached out to Ms. Novak and asked if they intended to renew the permit. She received the following response. Hi, Alicia. I'm under contract to sell the condo, so I'm not renewing the STR permit. It will be the responsibility of the new owner to obtain. Currently, we are scheduled to close mid-August. Thank you, Courtney. June 13th, of 2019, the permit expired. No, I apologize. That would be of 2023. On August 17th of 2023, the appellants Jennifer Suppett and Michael Dang acquired 2523 Clifton Avenue. On November the 6th of 2023, Metro's compliance contractor, Gronicus Host Compliance, identified the Airbnb website advertisement. In January, the property address was on the monthly list provided by Gronicus Host Compliance for advertising and operating without a permit. On January the 11th of 2024, Inspector John Feltz followed up on the property. He confirmed that the ad was posted and a notice of violation was sent. On January 25th of 2024, on or about this date, Inspector Phelps followed up by reviewing the website advertisement. The advertisement remained posted and there were several documented stays. Inspector Phelps made a site visit to the property to post a stop work order. When he arrived, the property owners were present and Inspector Phelps spoke with them. They said that they had not received a notice of violation, which we confirmed as the notice was returned to our office as undelivered. Since Inspector Phelps spoke with the owners, he did not post the stop work order. On February 10th of 2024, the advertisements were removed or corrected, and the case was closed. Veronica's host compliance tracking recorded 3 documented stays in January and 3 documented stays in February of 2024. February 28th of 2024, the appellant, Ms. Subit, emailed Inspector David Frabit, in which she wrote, "I purchased the condo a few months ago with the understanding that the short-term rental permit obtained by the previous owner was transferable upon the property's purchase. This belief was reinforced by the information I received during the purchase process, assuring me that I could utilize the existing permit for short-term rentals." On February 29th of 2024, the realtor Penny Tenpenny emailed Inspector Frabit, in which she wrote, "I want to apologize to you and Michael and Jennifer because I thought since the entire complex was short-term rentals that the HOA did the permits and that each condo did not have to do a permit for each. The listing realtor never mentioned anything about permits, and I have sold homes that needed permits, and I knew they were not transferable, but I had not sold in a complex where the entire subdivision was allowed to be short-term rentals. This really was my mistake, and I do ask that you not hold this over the buyer for he had been misinformed by Nick and me." Inspector Phelps replied, "Jennifer and Penny, it is indeed an unfortunate situation, and I understand how operating under an assumed STRP permit can happen. The unfortunate answer is we do not have the ability to act outside of the law as stated in the Metro Muni Code, 6.28.030 B to A, requirements and restrictions. No person or entity shall operate a STRP or advertise a residential property for use as an STRP without the owner of the property first having obtained an STRP permit issued by the Department of Codes Administration in accordance with the provisions of this chapter. Upon a determination by the zoning administrator or the zoning administrator's designee that the short-term rental property has operated without having obtained a permit, there shall be a waiting period of 1 year from the date of such determination by the zoning administrator or their designee for the property to become eligible for an STRP permit. You do have the ability to appeal to the Short-Term Rental Board of Appeals. The entire email thread is included in your case file. On March 1st of 2024, the appeal was filed. The case was scheduled for April of 2024 in the STR Appeal Board meeting. The appellants flew in from California. However, we failed to achieve quorum. The meeting was canceled, then rescheduled for May, but the airline canceled the flight at the last minute as several airlines were hacked. Staff recommends leniency.
Great. Any questions for staff before we hear from the appellant or the appellant's representative? Hearing none. Ma'am, we're going to have you open the microphone. There should be a little button right there. When the green light is lit up, you're free to talk. Give us your name and your address for the record, and then you have 5 minutes to tell us about the situation. Don't feel that you have to use up the whole 5 minutes if you can do it in less.
Thank you so much for seeing me. My name is Penny Tenpenny. I live at 505 Downey Mead Drive, Franklin, Tennessee, 37064. This property that we're talking about is at 2523 Clifton Avenue. And really, Michael and Jennifer are precious people, and they would want to go with every law that was needed. And I really do feel that it was my mistake. So I made the mistake. I I made a mistake there. So I hope you all will allow this to start as soon as they can, because I know it's affected their income on what they bought. They live out of town. They bought a rental in Nashville for use of this property to be done this way, and that they could come in and stay periodically. I don't know of anything else I can say except we would appreciate a leniency on this. Thank you.
Anyone have any questions? Sean, please go ahead.
My questions are for staff. So
yeah.
if I can wait for those if folks have questions of the appellant's representative.
Does anyone have any questions for Mrs. Tenpenny before we stay put, though? We might come up with something, so.
So because this case was filed quite some time ago, what standard are we weighing it under? Is it under the kind of revised flexibility, or is it on the old where we would have to find that the zoning administrator had erred?
Right, so according to the file here, the appeal was filed March 1st. So, and the new new ordinance became effective February 8th.
Okay.
So you would have you could use the factors.
Thank you. And maybe Mr. McBroom might know this offhand. Is it the case, as was indicated somewhere in the emails of the case file, that this complex is, there are multiple short-term rental permits, this majority of short-term rental or completely short-term rental?
Yes, sir, that's correct.
Okay. So, those were my two questions. I can kind of share my thoughts on this if y'all are ready for that, or
Look,
should we close
just
the public hearing?
Double check with Matt before we close the public hearing. We only learned about this case due to the scrubbing, right? There were no complaints about.
No, there were no
property.
no complaints.
Okay.
It had operated briefly, but there were no complaints.
Okay, yeah, terrific. Anyone else have questions either for Mr. McBroom or for Ms. Tenpenny? Nope. Okay, why don't we close the public hearing and we'll discuss amongst ourselves and come to a decision. Thank you so much, ma'am. You're free to take your seat.
Do I need to stay?
Yes, ma'am. We're going to be quick, so you can grab your seat and we will be efficient. Okay.
I can start with my thoughts.
Please.
So looking through the email record, these folks became aware of the issue in February, ceased operation, took all efforts to come into compliance. That's one of the first things that I look for in any case. So it looks like from the record we have as of March 1, there was no additional unpermitted short-term rental activity. I do want to be kind of clear. I'm sympathetic to the misunderstanding, the miscommunication about the permit transferability, but that's not what drives me to consider some leniency here, because it's really got to be on the operator of these short-term rentals to make sure that they are getting permits, and you can check with the folks in the codes department if you're out there and considering doing this. And that would be my recommendation if there's any question about eligibility or transferability. But just looking at the totality of circumstances, especially given the immediate actions taken toward compliance, this would, in my thinking, land us at like a 6-month reduction, which we're already starting from March 1st, we're already in like the 7th month of. So I'm inclined to support leniency that would allow them to apply for a permit tomorrow.
I agree.
Yeah,
For all the same reasons.
I agree with the rationale as well. I was going to point out, if no one else did, that I do think that, we can't necessarily say that it's excusable to pawn off your responsibility onto your realtor or another party unless you sought out legal counsel to actually advise you on those things. I think you sort of adopt the risk of perhaps getting it wrong if you don't bother to inquire, especially in an arm's length transaction like a real estate transaction. I think you have a duty, if you know that you are going in intending to exploit the property for commercial purposes. I think you have a duty to figure out what your obligations are there, and you can't leave that to someone else. But I do think that they also took pretty immediate steps to come into compliance or ascertain requirements. So I would be in favor of leniency as well.
Anyone else? Do you want to make a motion?
I'll make a motion that the appellant is granted relief to the extent that they're eligible to apply for a permit September 26th.
Second? Can I see a show of hands? Great. Okay, so where is Ms. Tenpenny? Okay, so we have found in favor of the appellant, you can let them know that they can reapply. Thank you so much. You're good. Thank you so much, ma'am. You have a great day. Okay, what's next?
Our next case is 2024-018, 603 South 20th Street. Michael and Stephanie Jorgensen is the appellant present. Is there opposition present? Therefore, each side will be given 10 minutes. This permit was revoked based upon the finding of the Codes Department that the SDRP is not the primary or principal residence of the owner. This is an RS5 zone district in which only owner-occupied permits are allowed. This is governed by BL 2020-127, and the board has discretion under BL 2023-136. The previous owner had an owner-occupied permit from October 4th, 2019 through October 4th of 2022. There were 4 website advertisements associated with this permit, 2 Airbnb, 1 VRBO, and 1 Flipkey. On September 28th of 2022, Mr. Michael Jorgensen acquired the property at 603 South 20th Street. Then on the same day, Mr. Jorgensen transferred the property to his wife, Stephanie Jorgensen, by quitclaim deed. On October 12th, an owner-occupied STRP permit application was submitted. On October 13th of 2022, a complaint email was received from a neighbor claiming that the property was already being rented as a short-term rental property by the permit applicant and the owner. Prior to making application for the permit, and that the owner's primary or principal residence was at 52 Barn Street, Mount Juliet, Tennessee, 37122. Also later that day, this complaint email was shared with 2 other neighbors and was subsequently forwarded to the district council member, Mr. Brett Weathers. Councilmember Weathers in turn forwarded it the following morning to Inspector John Feltz and Inspector David Frabit. On October the 14th of 2022, in addition to the email from the council member, there was a separate email received from another neighbor on this date, which also reported that the property was already being rented as a short-term rental property and that the property is not the owner's primary or principal residence. This email included photos of website advertisements, proof of ownership, 52 Barn Street, Mount Juliet, Tennessee 37122, and of STR guest on the deck that 603 South 20th Street. Inspector Phelps began an investigation, and Inspector Frabit put on hold issuing the permit. Inspector Phelps verified from the Office of the Controller of the Treasury of the State of Tennessee that Michael and Stephanie Jorgensen own the property at 52 Barn Street, Mount Juliet, Tennessee. He also confirmed that a VRBO and a Flipkey advertisement for 603 South 20th Street were currently posted on their respective websites. On October 20th of 2022, Inspector Robert Osborne received another email complaint from a different neighbor in response to being told by other neighbors that the owner of 603 South 20th had applied for a permit. Inspector Osborne asked Inspector Phelps to make a site visit to the property the following day, which was a Friday, in an attempt to make contact with visitors renting the property on a short-term basis. On October 21st of 2022, Inspector Phelps made the site visit and in fact did encounter guests at the property and admitted they were renting on a short-term basis. Inspector Phelps gave this information to Inspector Osborne, who in turn denied the permit for advertising and operating prior to obtaining a permit. In accordance with BL 2020-187, this required a one-year wait from the date of the last document stay before another application for an STRP permit could be submitted. On October 24th, 2022, Inspector Osborne updated Councilmember Withers that the application was denied due to advertising and operating before obtaining a permit. February 23rd of 2024, an owner-occupied STRP permit application was submitted by the property owner, Stephanie Jorgensen. The proof of ownership of owner occupancy submitted was her Tennessee driver's license and her life insurance policy. The permit was issued on February 26, 2024. March 1st of 2024, I received an email from the district council member, Clay Capps, and a number of his constituents had contacted him after receiving the mandatory neighbor notification letter, and I had to inform him that the required documentation for proof of owner occupancy had been submitted and the permit had been issued. I asked Inspector Phelps to open a case and investigate if this is the Jorgensen's primary principal residence. Inspector Phelps found the Jorgensen's automobile is registered at 52 Barn Street, Mount Juliet. Also, both Mr. and Mrs. Jorgensen are registered to vote at 52 Barn Street, Mount Juliet. Both Jorgensens work for Car Incorporated, which is a specialized healthcare realty company. His real estate license is registered at 52 Barn Street, Mount Juliet. Mr. Jorgensen's Tennessee driver's license is also registered at 52 Barn Street, Mount Juliet. And on May 5th of 2023, Ms. Jorgensen was cited for high grass and weeds at 603 South 20th Street, which is the property on appeal today, by Inspector Mark Pennick from the Property Standards Division of the Metro Codes Department. The notice of violation was mailed to that address. The inspector's notes from the case read as follows: 5/19/23, still in violation. Left door hanger extending 2 weeks. 6/2/23, this property is vacant, sending a new letter to new address for owner, 52 Barn Street, Mount Juliet, Tennessee. On 6/7/23, received a voicemail from Mike Jorgensen, tried to call back, went to voicemail, mailbox full, sent text message. 6/15/23, attempted to reach Mike Jorgensen again by phone and no answer. The grass was not cut within the specified remedial time period, resulting in a warrant being issued by the Metro Department of Law to appear in the environmental court. The warrant was served at 52 Barn Street, Mount Juliet, Tennessee. On March 3rd, an email complaint was submitted to the STRP questions at Nashville.gov mailbox by a neighbor that had received one of the neighbor notification letters. The neighbor claimed that 603 South 20th Street is not the owner's primary or principal residence. On March 4th of 2024, Inspector Phelps was forwarded the email and responded that an investigation was underway. On March 15th of 2024, the revocation letter was sent. In accordance with Metro Code Section 6.280.030.A.5.L.III, the revocation letter allows 15 days from the date of the letter to cease STRP activity. On March 28th of 2024, the revocation went into effect. April 10th of 2024, the appeal was filed. The photos documenting Inspector Phelps' site visits to both 603 South 20th, Nashville, Tennessee, and 52 Barn Street, Mount Juliet, complete the evidence for this appeal. The complete package of the 2024 email complaints, as well as the email correspondence with Mr. Jorgensen, is included at the end of the case summary. On April 17th of 2024, the website advertisement was removed. On September 17th of 2024, another email complaint from a neighbor with documentation included was received. This was included also in your package as it came in under the deadline. The last documented stay was in 2022, but the permit was issued on February 26th of 2024. The email from the council member Capps came in on March 1st of 2024, and an investigation was initiated, and the permit was quickly revoked on March 28th, 2024.
Can I just confirm my understanding of this with you before we let you go, Mr. McBroom? The high grass and weeds citing and the warrant there from environmental court, what have you, that all happened in the spring and early summer of 2023? It just was part of the investigation as they were looking into the property?
Yes, the fact that the warrant was served at the Mount Juliet address.
Got it. Okay. Anyone else have any questions for staff before we hear from the appellant? So quiet today, everyone. Okay. Ms. McBroom, thank you. Mr. Jorgensen. Hi. We're going to have you open that mic up so that you see the green button.
I think I'm good. Can you hear me?
Good. We're going to have you state your name and address for the record, and then you can tell us about your situation. Now, keep in mind, as you heard Mr. McBroom say, you've got 10 minutes.
Okay.
But you're going to want to save some of that time in case you want to rebut anything we hear from your neighbors or those who've come to the meeting today to oppose your appeal. So keep that in mind. And also, if you don't need 10 minutes, don't feel like you have to use it.
Awesome.
Sure.
Clock starts now.
Yeah, please.
All right. Well, thank you guys for allowing me the ability to share the story. Honestly, we did move into this house, and John came and was there last week, and I did not realize that there would be such a crowd behind me. I wish the microphone was facing the other way, honestly, because I would love to tell them face to face the story, but unfortunately it's not. So I'm going to tell it to you guys, and I just hope more than anything that the three things I would ask is not to hold what happened previously against us, the previous owner. The second thing would be to have an open mind with our situation. It is a unique one, I would suggest. And then this is to the neighbors, but no matter what happens here, I would hope that you would give us a chance because we are your neighbors and we have a fantastic family. I know I've seen how close you guys are walking into this meeting, and I love that. But I'll get started with the story because I know I'm going to need some time, I'm sure, to rebut. But we have a unique situation in our family. We have 4 children and we homeschool, and I have a role, as was stated in the case, in commercial real estate. And so we have agents all across the country. So we've always had a dream of traveling with the family. And in July of 2022, we started looking at what that would look like. And we found this house in East Nashville. My wife has always loved Nashville, East Nashville in particular. She had the thought of maybe this being our forever home anyways. But this did allow us to potentially have a short-term rental permit, which our Mount Juliet home did not offer. So in July of 22, we got it under contract. In August of 22, my daughter was diagnosed with leukemia. And that kind of put everything on pause for us in terms of what this meant for the property. We did decide to push forward because there was a thought with leukemia that if you get a temperature of over 100.3, that you need to get to the hospital immediately because there are certain things that can happen. It's not usually leukemia anymore that is cause for mortality. It's actually the treatment. And so we had a thought maybe that we would be living in this house for that purpose. We thought maybe this was the reason that it happened the way that it did. So we went to get the permit, and it was denied because we were fulfilling a request of the previous owner to have a friend stay there for that weekend. And that was what was noted as the short-term rental stay. We had a property manager that she previously used that we were going to hire on because we had so much going on that I didn't feel like I could handle it myself. And he failed to pull that last. He canceled 2 weekends of guests and did not cancel the third. And I almost came to appeal this. I spoke to an attorney, and he suggested that my best case of action there was actually to sue the property manager because they messed up. But we didn't feel like getting into a legal battle in the middle of this all as well. So we pushed through sorry, I did make notes because I didn't want to forget. As we progressed with treatment, the kids didn't end up wanting to move. Mom and Dad were, one of us at the hospital, one at the house in Mount Juliet. And the plan to move to the South 20th Street address, we did not fulfill, or we didn't finish that because the kids just wanted some normalcy in our lives. Couple months later, my father passed away, and I was the executor. Had a ton of work that came with it, but it did, and this kind of goes to the grass issue. We had a lot of stuff going on in our lives at that time, but it also did allow us to keep this house. Obviously, having two houses is not easy for anybody when there's not income on either, and so it did allow us to keep this house and keep the dream alive of traveling. And then that winter, though, was 3 months. We had 3 months out of the 5 in the hospital because there were just so many stays with Ainsley. And so the longest stay was in April. That's when a lot of this stuff, one of the bad things that can happen while you go in for the temperature did happen. We had 3 big issues that happened all at the same time. Fortunately, she was good. But we did not violate anything in the punishment, if you will, whatever you would call that, for that year. In fact, we stayed longer. We didn't move forward with a permit until February of this year because we weren't planning on moving at that time. And so when we put in the permit, did everything we could to make sure that we were abiding by the laws. Hadn't planned to move right away, but we wanted to do some work to the house and didn't want necessarily to have, be going back and forth. And so that, I think, is where the question of the owner occupancy arose. We absolutely intended to. It was just a matter of getting everything done all at the same time. We looked into appealing initially, but then had the thought of maybe this is all, maybe we just need to move on. There's going to be opposition in the future. We did put the house up for sale and didn't feel like going below the asking price. And so we decided in the middle of the summer that we were, in fact, going to move in regardless of what happened with this appeal. We were excited to travel. Our hope is that we could travel and have this house open for some sort of income to help with the travel. But if it doesn't end up working, we understand. We're here anyways, that this is our home. And so last week we were moving in. John came by and he had almost this idea of like, hey, what are you guys doing? Like, you have an appeal next week. Is this a show to say, hey, we live here? And that's when I actually realized how much opposition there was. I had no idea before. The realtor and the property manager acted like maybe there was one neighbor that was unhappy with it. After reading the file, I can completely understand why there would be such opposition because of this house. And we're frankly quite appalled by some of the stuff that happened in the house previously. But I do, again, want to be clear that none of that happened under our watch. I walked through this with Stephanie last night, my wife, and she was mortified at the fact that there was, people investigating us. And she just was like, why is this happening? And I told her some of the stuff that we found in that briefing and said, what would you do? Meaning there were, some of the guests that were staying were appalling. And she said, I would actually do the exact same thing. And she also said, it actually makes me feel really good about this community that they're appalled by that too. So we do live there. It's not a question. We have a lease in place for the Mount Juliet house. And so that's our case. Again, my ask for those behind me is that you'd give us a chance regardless, because I do have a fantastic family, the least of which is me, but you guys would love them, and I hope that we can get to know each of you. So I'd like to stop the clock because I know I'm going to need some time back.
You will have 3 minutes for a rebuttal.
Okay.
Does anyone have any questions for the appellant? This won't count against your time. But
Okay.
before we hear from the opposition to the case, does anyone have any questions for the appellant?
Yes. Mr. Jorgensen, when did that lease begin that you just executed for the property in Mount Juliet?
So that lease began on Saturday, I think. It was recent.
Okay.
So we had plans we knew that the house was going to rent easily, evidenced by the fact that it took 3 days and we had 8 applicants. And so we knew it would rent quickly. The thought was to do this earlier, but given the situation, we did not move forward with it at that time. We did in August, and the lease started in September.
So you said last Saturday, which
The
was
21st, I believe, was the
21st?
date. Yes, sir.
Are the new lessees in the property now?
Yes, sir.
When did they move in?
The 21st.
Okay, got it.
What's the length of the lease?
It's 14 months. It's until December 1st of 2025.
And did you provide a copy of that lease?
Yes, ma'am. It should be the last thing on there.
Okay. Working my way
Yeah,
through.
let me go back.
It's a thick file. I'm sorry.
Got it. Okay.
Yeah.
I believe it begins at page 135.
Yeah. Any other questions for Mr. Jorgensen before we hear from the opposition? Okay. All right. There seems to be a little bit of a crowd, so why don't could I trouble you to take a seat over
You want me to
there?
turn this
And
off?
you can leave it on.
Okay.
And folks, why don't you come up? As many as you'd like, but keep in mind, we only have 10 minutes, and that 10 minutes is to be shared by all of you as a group.
And to let the chairperson know, many of us met ahead of time, kind of knowing what the procedures were. I'm going to start off the group and I provided a written opposition, and then we would have witness testimony thereafter. What I would ask they're the witness testimony based on the procedures. What I would ask though, if somebody wouldn't mind, I don't want to go over 5 minutes to make sure that the other neighbors have the opportunity to speak. So if somebody could just let me know if I'm running over on time, because I want to make sure everybody gets an opportunity.
So I'll set a timer for, you got it? You got it, Alicia? So at 5 minutes, give her a high sign. Okay, terrific. Anyone who's going to speak, we need you to start with your name, spell it if it's a difficult spelling, and your address, and then tell us about your situation, your observations on this case.
All right, I'm Brittany Simpson. I live at 2003 Eastside Avenue in Nashville, Tennessee, and I'm representing one of the many neighbors here in opposition to the current appeal filed by the Jorgensens. Prior to this hearing, I provided a written brief that provided kind of a history of the property, sort of legal position as well. The primary basis for the opposition is the permit applicants did not permanently reside at the time that they filed their application. It was revoked, and at the time of the appeal, again, it was not their permanent residence. Under Metro Code, to qualify for the owner-occupied short-term permanent rental that you all are well aware of, the owner must permanently reside. It doesn't say that they intend to reside, that they plan to in the future. It says that they permanently reside in that location. Until last week, the property remained largely vacant, undermining their claim that they had permanent residence at the time that they actually filed for their permit. To the extent, they intend on making the primary their permanent residence, I would still say that this board should deny the appeal because at the time the application was filed, it was not their primary residence. And I think they're, based on the law and the grounds that I've seen, that would give this board plenty of opportunity to deny the appeal. But based on the applicant's history, we don't actually believe that they intend to live in the property. The applicants previously filed 2 false affidavits in submitting their previous permits, saying that it was their permanent residence, and at the time it wasn't. They were living out in Mount Juliet at the time. In addition, the applicants do have 4 children, is our understanding. This is the first that we had heard of Mr. Jorgensen, so I really do appreciate kind of hearing his story and background, but I don't think that changes kind of the history that we have seen, and what we believe is some of the dishonesty in filing the permits and what had been submitted previously. So the neighbors are here today. We don't oppose legal use of a short-term rental, but we are opposed to people making a profit at the expense of the neighborhood and the neighbors who live there. And unfortunately, that is what we had previously experienced with the previous property owner. We're actually in a unique position where we've seen how this particular law actually protects the neighborhood. We've seen this be used for a legal short-term rental and an illegal short-term rental. When people don't live there, we had really, really rowdy parties, trash up and down the alley. We ended up having raccoon and squirrel issues because they were getting in the trash. And it was most of these neighbors that were here who really care about the community they live in that ended up having to clean everything up at the end of the day. So I think you all know that the Jorgensens already purchased the property in September 2022. I don't want to go through that procedural history, but the property, we already had 1 violation of them renting out the property without a short-term rental. I was one of the people that filed the complaint. This was back in 2022, so I can't speak to it, but I believe that there was more than 1 short-term rental that took place in the time between they purchased the property and then when they were shut down. And so basically, I think the impact on the community, the kind of actions that we've seen, they violate the intent behind the short-term rental permit and our Metro codes. And we think approving this kind of appeal would set a dangerous precedence, allowing sort of absentee owners to be kind of coming into this neighborhood and, making a profit and not really taking care of it. Again, if there are neighbors, I think he'll find a very, very inviting community, but we still do not believe that it's actually going to be used for their permanent residence.
Hi, my name is Bertha Deshawn, and I live at 1914 Long Avenue. I'm in a unique situation where my kitchen windows, my dining room windows, my porch, and my garage where I park my car and come in and out of my house every day looks directly at the front door, the garage, the porch, and their upper deck of 603 South 20th Street. So I have been witness to see that there's been a vacant house there throughout 2 years. And I do have some evidence of once the permit was revoked, I believe that was March 28th of 2024, they did have some guests. I saw some cars parked with Georgia plates, and I happened to be at my driveway with my son playing outside. And I said, oh, hey, you're moving in, because they did have a young child. And they said, no, Airbnb. And I said, okay. So that was on, my documentation, that was on April 4th, April 5th when they arrived.
April 5th of 2024.
Yes. Thank you.
Thank you.
Hi, my name is Kelly Wilson, and I live at 2002 Long Avenue, and my directly neighbor, 603. And I can testify to the vacancy status of the house over the last 2 or so years, which is evident by an entire winter. All the lights were left on, and my entire backyard was illuminated because no one was living in the house. It's been largely vacant with the exception of the moving truck, which appeared on September 18th, 2024, 7 days before this appeals hearing today. The reality of living next to an Airbnb was, like they said, pretty appalling. While objectively entertaining, not something that I signed up for as a mom of 3 children, who I also homeschooled at the time. And upon one such day, in broad daylight, on a Saturday, dollar bills were raining down on my backyard. It was fun for each one of my kids. They got about $6 each, but highly inappropriate. So it was full of drunk parties from bachelorettes to whom this house is marketed toward, and all of the decor inside of the house caters to. Public urination off the rooftop balconies, cigarettes flung into my backyard, which my dog would eat, strippers during broad daylight. I said that. Trash all over the neighborhood, and all the animals that trash attracts, which Brittany had mentioned, which including but not limited to my own yard and including my elderly neighbors, Tom and Karen. And Tom was going through chemotherapy at the time, and he had to clean up mountains of trash in his yard. I love my neighbors. I love my neighborhood. Most importantly, I love my children, with which I do my very best to protect. And with that in mind, that is why I came here to have a public comment today. Thank you for your time.
Alicia, how are we doing on time? You've got 3 more minutes between the 2 of you there, or anyone else who wants to speak.
Thank you so much to the board for the opportunity to share my thoughts on this matter, and to Mr. Jorgensen as well. I come today mainly to...
Sir, we need your name and your address for the
Thank
record.
you. My name is Michael Hicks. I live at 1914 Eastside Avenue, just a couple houses down from this property. And my comments relate mainly to the secondary piece of this, which is how the short-term rental has been operated, and it's kind of the nature of the build of this property. This property is a very large house, and it has a very large terrace on the roof that unfortunately points directly into our neighborhood and to neighboring houses. We have other short-term rentals in our neighborhood that don't ever cause any problem, but this one was a very regular, almost weekly occurrence where there would be large parties on the terrace into the night. Many nights, I could hear the parties from within my son's bedroom when I was trying to put him to sleep, and we would use a noise machine to try to drown out the sound. The property innately attracts party groups into town, and so I feel that it's inevitable that it attracts these kind of groups, and it has been really detrimental to the family atmosphere of our neighborhood. And if this appeal is approved, I would just ask Mr. Jorgensen to please consider the needs of the community in the area. Thank you so much.
Hey, I'm Darcy Phillips, 2001 Eastside Avenue. I similarly wish I could turn this around. I just want to say In a unique position as a survivor of childhood acute lymphoblastic leukemia, I deeply empathize with your situation. And if you guys have moved into this community, we look forward to supporting you through that chapter.
Thank you. All right. Mr. Jorgensen, I think you have a 3-minute leftover bit if you would like to address anything that you heard.
I would. Thank you guys for being here, and thank you for taking care of the community like you do. The biggest thing that I would ask is, I know that you feel like there's dishonesty in the fact that we're living there. We truly are. We don't have anywhere else to be. That house is rented out. In terms of saying that it was dishonest in the past, we had intended that first time to move in to be closer to Vandy. And then when it was denied, we ended up not. And in this case, we did intend to earlier in February, March, whenever it was. I did scour, and I told this to John when he was there as well, to figure out what I needed to do to make sure that we were compliant. I don't know about that April stay. I'm completely unaware of anything. As soon as we got the notice from John, we pulled everything down. We canceled guests. It was unfortunate for them, but we did. It seems like the majority of, and Darcy, I appreciate your story too. Your husband actually was out the first time we moved in, and he told us your story, and I thought it was exciting that Ainsley might have somebody who had such great success through ALL. And so we're hopeful that she has the same. But it seems like the majority of the issue with the neighbors is how it was handled. And I know you don't know me, and there's a lack of trust already, but I have zero intent of allowing my children to sleep in a house where stuff like that is happening. We are very open to changing it. In fact, we discussed it last night because, again, we had not heard any of these stories until we had received this packet that you guys had, and it was completely appalling to us. Strippers and, dollar bills flying around is completely contrary to who we are as people. And if that's what is attracted to this house, we have no part of that. So that is definitely not our intent to keep it that way. I'm hopeful that if it is approved, that we can be more like your other neighbors who have those Airbnbs as well. So I think that's all I've got, unless they have more.
Nope. We're not going to have a conversation between you guys. You're going to speak with us. And
Yes, ma'am.
if we have questions for you, we'll pose them to you, but we're not going to open it up to a debate.
Okay.
Does anyone have any questions for Mr. Jorgensen before we close the public hearing and discuss this amongst ourselves?
I do. Did you list the house for sale in July of this year?
Yes, ma'am. That was after it was denied when we got that notice. We initially were planning to appeal, and we discussed, does this make sense, or is this going to be an ongoing thing? Which it seems, if the house was run like it currently or previously was, then it would be an issue. But yeah, we decided to see what the market would look like if we could sell it, and then maybe there would be another opportunity. But it did not end up selling, and we took that as, hey, let's go live it now. Ainsley now is in treatment, a phase of treatment where she only has to go monthly. And so we can travel more. And this does allow us to do so if it was approved.
When did you pull the listing?
Last week, or it was not last week. It was earlier this week. It's Wednesday. I messaged him on Saturday. And I think he got it pulled.
Moved in and then you pulled the listing.
Correct.
Okay.
She raises a question for me. So the revocation, you became aware of the revocation on or around March 28th, correct?
Yes, sir.
But then the listing decision wasn't made until July.
No, it was listed in July. We discussed it and we pulled back on the appeal. I don't remember what date that was. That was months ago, but maybe May-ish. I think we were supposed to be on the May docket. Is that in there when we pulled back on the appeal?
I don't see anything to that effect.
Nope. I see the appeal was filed on April 10th.
No, so we did not obviously appeal. This is the first you've heard this case, but we pulled back at some point, and that's when we decided to list. I don't know, does it say July? I don't know what date we put it up. Honestly, I'm not.
I believe that's what you just said to Ms. Kimmerling.
I believe, I I hope that's not held against me if it's incorrect. I believe it was July when it finally got up, but we obviously had been speaking to an agent prior to that. But if it was June, then I'm not sure what date it was. I can look.
Soliciting the information, you'd be in the best position to know.
If you'd like me to, I can pull it up on my phone right now. I do believe it was July.
Okay.
Anyone else have any questions? No? Okay. Thanks, Mr. Jorgensen. Appreciate your time. You can grab a seat. We're going to discuss this amongst ourselves. And just an FYI for you and for everyone else, this is an opportunity for us to discuss, and the public hearing will be closed, so we don't need to engage in any crosstalk, okay? Thanks. Okay. Thoughts, Sean?
Yeah, so I'm really struggling with the date that the application was submitted and the date that the appeal was filed and the date that the appellant says that they moved into the property. We've had cases like this in the past where we've determined that, maybe relief from this body is not what is your best course of action, but there's no penalty associated with having a permit denied. So perhaps stay at the established residency at the property and then reapply for a permit would be a better course of action, because I can't get to where we'll listen to discussion, but we would be finding in the appellant's favor on a permit that we know was not proper. The permit, when applied for, said, I live here, this is my primary residence. And then, if it was found not to be the case, and then the appeal was filed, again, I would kind of take that as an attestation that I do live here. But then it's been very clearly stated that they moved into the property just in the last 7 days. So I don't think appeal is the right path for this. I think staying at the property and establishing residency and then applying is the correct path forward.
And I think we have arrived there on a number of cases lately, that when circumstances change in your living situation, circumstances can change in your permitting situation. But we're being asked to say that either say that the zoning administrator erred, which he very obviously did not, or that some relief is due, which I don't see how it is. So I don't think either.
Yeah, I don't either. I mean, there was an admission that they were not living there prior to the execution of this lease, which the term just began on that last Saturday. So there's no competent evidence to suggest otherwise, that at the time that the application was filed, they were not occupying the residence that's at the subject of this appeal. So I don't support finding that the zoning administrator erred or any grant of relief, if appropriate, under the code, or if allowable under the code.
I think that we've heard a lot of information in this case that, as Councilmember Parker alluded to, has potentially taken thought processes in different directions. But for me, ultimately, pulling all of that information out, and we have to look at whether or not the revocation on March 15th, 2024 was an error. And at that time, admittedly, from the appellant, it was not his primary residence. So there was not an error on the zoning administrator's part at that time.
Right.
So I agree with what's been said thus far, that the appeal is not necessarily the right avenue for this. Establishing residency as a member of the community and that neighborhood, and then reapplying is likely the best course of action.
Mike, what do you think?
Yeah, I agree. It comes down to, at the time of the permit, if they're a resident or not, and they said that they were not residing in the property, so I think it's pretty clear.
Does anyone want to make a motion?
Yes, I move that we find that the zoning administrator did not err in revoking the permit on March 28th, 2024, and that any request for relief is denied.
May I?
Oh,
Sure.
May I clarify with staff, is the nature of this appeal challenging the revocation Or is the nature of the appeal about a determination regarding a new permit that was applied for?
This is concerning the revocation.
Thank you. Then, hearing that, I believe your motion's appropriate if you'd like to.
I think you could just second it.
Hearing that from staff, I will second the motion.
Can I see a show of hands? Okay, we're unanimous. Mr. Jorgensen, sorry, we're not going to be offering you any relief today, but it does sound like you've moved into a pretty wonderful community, so we wish you all the best. Thank you so much. Have a great day. All right, what is next?
80 zone, which allows only owner-occupied permits. This is governed by BL 2020-187, which requires there's a typo there. This requires a 6-month wait period. The board has discretion under BL 2023-136. On July 9th of 2015, the property was acquired by the appellant, Mr. Webb. On July 21st of 2023, an owner-occupied STRP permit application was submitted. On July 28th of 2023, the permit was issued. On July 25th of 2023, an Airbnb website advertisement was posted, and on October 26th of 2023, a VRBO website advertisement was posted. On April 29th of 2024, a 60-day renewal notice email was sent. On March 14th of 2024, a 45-day renewal notice email was sent. On June 1st of 2024, a second Airbnb website advertisement was posted. On June 28th of 2024, the permit expired. On July 1st of 2024, the 30-day grace period was initiated. Administrative Assistant Alicia Buffer emailed the owner inquiring if he intended to renew the permit with no response. On July 28th of 2024, the 30-day grace period expired. On July 29th of 2024, Administrative Assistant Buffer again emailed the owner informing that the 30-day grace period had expired, and again, no response. On August 13th of 2024, Mr. Webb came to our offices and met with Inspector David Frabit. There had been 2 documented stays in July 2024 after the permit had expired, requiring a 6-month waiting period to reapply, and the appeal was filed. On August 15th of 2024, the last website advertisement was removed. There were no complaints for the property on the short-term rental property hotline or on the Hub Nashville.
All right, thank you. Does anyone have any questions for staff before we hear from the appellant? Nope. Okay, Mr. Webb, terrific. If you would be so kind as to give us your name, your address for the record, and then tell us about your situation. Keep in mind, you've got just 5 minutes, and if you don't need 5 minutes, don't feel like you have to use it. Is there a little green button lit up? There you go.
Good afternoon. My name is Roderick Webb, 676 Brick Church Lane, Whites Creek, Tennessee. I am a 24-year educator, and I chose the route of doing a short-term rental on my home to supplement my income. And I started this process last summer, and I had a property management company who managed the property. One thing about the property, I'm not sure how relevant it is, but it's on a 5-acre tract, so I don't have any neighbors, and it's way, way, way off the street. And so I had the property management company, and so this past summer, I decided that based on the amount of money that the property management company was getting, along with the other expenses, I decided that I was going to become the property manager myself, which is why you see a new listing came up in June, because I had to close the old listing because the property management company was in charge of that. As far as those emails, when I did get the packet the other day, I have to accept that responsibility myself of not checking that email account and knowing that I had received those emails. Upon finding those emails, I immediately contacted the office downtown, and I went down there that afternoon when I got off work, and I spoke to one staff member, and then I went down the next morning and I spoke to another staff member. And once I realized, again, not trying to point blame or anything, I did receive a couple of emails in error. I got an email on July 1st saying that it was a 60-day renewal permit notice. So in my mind, I'm thinking I have 2 months. And so about 6 weeks after that is when I was like, I know I need to go ahead and take care of this. I had not physically read the entire email, understanding that the permit actually had already expired. And so upon meeting with them and finding out that there was nothing else really that I could do, I went ahead and removed I removed it from the Airbnb website. I ended up having to cancel 6 reservations totaling about $4,000, in which I have lost. And so I guess I'm just coming asking for whatever relief can be given, because as soon as I became aware that I was in violation, I did remove the listing and have those reservations canceled. And I'm just hoping that whatever relief can be given so I can resume operating the short-term rental with the permit.
Very good. Any questions for Mr. Webb?
Mr. Webb, you said that you received on July 1st a notice that said you were 60 days out from the expiration.
I received an email on July 1st saying the email was titled 60-day renewal notice. So, and I didn't, and again, I did not read the email. I did see the title. And so in my mind, I've got 2 months.
Right. I've got the email right here. The subject line is 676 Brick Church Lane. And I understand your point, because there is a kind of a general note on here that Alicia has on all of the emails that says, are you receiving your 45 to 60 days renewal notification through your mail, through your email? If yes, which folder, inbox, spam, junk, or not receiving through any folders at all? Please reply along with responding to below. Below, had you read it, it says, your STRP for 676 Brick Church Lane expired on 6/28. And the emails before that said so this was, expired on 6/28. So, I mean, we all miss emails, but that it didn't say you've got 60 days in the header. It just had your address. Actually.
I don't know. I mean, I went down to the office and showed them the email. The email was titled 60-day renewal notice.
Mm-hmm. Let's see.
That was on 4/29, that you got 60-day renewal.
I got that email on July 1st. I'm not saying that I didn't get that email on the date that you're saying, but I'm referring to the email that I know that I did see I got on July 1st, and I was under the impression that I had 60 days to get this rectified. But again, I'm not pointing blame at anyone. The responsibility is on me. I did at least want to make that known, because that is where I kind of got tripped up.
Great.
Got it. Let's see here.
Any other questions for Mr. Webb?
I don't. I actually have a question for the city now.
Okay. I think we can do that.
Okay. Do we have any document stays after July 28th?
The documented stays, VRBO actually lists the dates. Airbnb does not. It only lists a time period. And so what I have on the Veronica's host compliance tracking just shows 2 documented stays in July. It does not indicate whether any of them occurred after the 28th, but then there were no further stays after that.
Okay.
Anyone else?
I actually have a follow-up question now.
Go.
So, Mr. Webb, to make sure I understand you correctly, you did not read any of the emails that the city sent to you regarding your upcoming renewal.
I have multiple email accounts, and I've made some changes within my organization, but had I got the email, I would have taken care of it.
And so how did you come to understand that your application, that your permit had expired and that you needed to do something? Because fairly quickly after the grace period ended, you showed up within 2 weeks of that date, you showed up at the office to speak to someone.
I contacted them on August the 13th via email, because again, I did see an email come through on July 1st. Again, I didn't open, I just saw the heading and it said renewal 60-day notice. So I was under the impression that was telling me that I had 60 days to get my permit renewed. And I contacted them and so when I went into my email to take care of this on the 13th is when I actually read the email, and that's when I emailed them and I went down there and spoke with them 2 days, which was actually, I believe, the 13th, and then the next morning on the 14th, and that's when I removed the listing from the website.
Got it. And then when were the documented stays in July?
July, one guest left on the 28th, and they were there the 24th through the 28th, and then there was another guest towards the beginning of July, that second weekend.
Okay, thank you.
Anyone else? Nope.
And so can I say one more thing? I don't know.
You can say one more thing and we're going to close the public hearing.
Yes. So it was within that grace period when those 2 stays did occur.
Right. The grace period, just perhaps it's a term of art, but the grace period is an allowance for you to have had your permit expire, but you can still apply without it being considered that you have missed your window. So it isn't so much a grace period like, oh, just go ahead and keep operating. I don't think that's the intention of the grace period, but I get your point. And we do have a list of the emails. So regardless of what we decide today, regardless of how this works out, your reweb35@gmail.com is the account that the staff has. This is what they're using to communicate with you. And the 60-day notice was sent 4/29. A renewal notice was sent with the headline permit expires 6/28 in the subject line. That was sent on May 14th. Another one was sent permit expires 7/28 because it was accounting for the grace period. That was sent on 7/1. So it's not like a Herculean efforts weren't taken on the part of staff when they're not even required to do this. So keep that in mind. If you're going to manage this going forward, they're not required to do this. This is all courtesy. So you need to know the dates. You need to be on top of it yourself because there's no guarantee that you will always get an email. All right. So, but thank you so much for all the information. We're going to discuss this amongst ourselves and we'll have a decision. So you can go back to your chair if you like. Okay.
Let's see here. Let's see.
So I'll start.
Go ahead.
This is one of those cases where it is kind of just, it's a paperwork thing. It's a change of management thing. This hasn't been a target property where, it's really a nuisance to the neighborhood. It's kind of a no harm kind of situation. At the same time, like we seldom have that list of like the emails are sent. It's like, come on, we're trying to help you out here.
Yep.
So, I feel like we could offer some relief. I don't want to be overly generous, but I also don't want, when you keep in mind the rules that have been, or the suggestions that have been laid out for us in the latest ordinance, he did make 2 in-person appearances, trying to get to the bottom of things. He did cancel some cancel some guests and remove the listing the day of or the day after having an in-person visit with these guys. So there were some, notable efforts to comply.
And just to note, the required wait as determined by codes is a 6-month wait, which I believe would be beginning in,
That's right. This isn't a 1-year wait. It's a 6-month wait.
we're not starting from a year. We're looking at 6.
We're looking at 6 months. Okay.
And allowed to consider the factors. as
Sure,
well.
sure.
Right.
Sure. You
So
look
that,
vexed, Mike.
Yeah, I guess that was a clarification, is what it says on the docket, that it's a 1-year wait period.
He said at the start that it was just
Okay,
a
I'm
typo.
sorry. I
Yes,
missed that.
It's
Thank
6
you.
months.
Okay.
Well, then, since I'm talking,
We got something out of Mike.
yeah, I mean, I do see this as an oversight. And I know that, I mean, and it's a courtesy. I'm inclined to offer some relief, although I'm not inclined to offer full relief.
right.
So I'm somewhere in the middle, so I'll be open to suggestions.
Yeah. I
Okay.
think I'm saying this, it's sort of, the admonishment that just went forward on the lack of diligence. When the office has made what I would call significant efforts to communicate and make sure, and then, I guess sort of seeing a relevant email, but not bothering to read it. It doesn't look the best, but I'm looking at what we typically consider in cases like these. There were documented stays up to the grace period expiration. There were no documented stays after, and no questions concerning those. There was reasonably prompt action in attempting to find out what the situation was and cure the default as to his obligations as a permit holder. So I am inclined to support offering some relief. To what extent, willing to hear from the board and agree with what sounds reasonable.
Well, we're looking at July 28th as the last documented stay,
Yes.
right?
Yes.
So that's what we're going to work off.
So that would be
Right. So that would put it February if no
28th is the
relief.
6 month.
Right. If
So
no
what-
relief's granted.
How do we want to split the baby? Very weary, aren't you? Is 3 months overly generous?
I could entertain 3 months.
Is 3 months overly punitive? I'm trying to get a read out of Whitney.
No, I don't think it's overly punitive. I think that it is important to note, as has already been said, he's an individual operator. This would be his first permit renewal. He had just taken over management himself. There are no complaints. He's on a 5-acre tract of land. This is exactly what sort of this board was designed for too. So I don't think 3 months is overly punitive, but by the same token, as Mr. Bond correctly pointed out, getting a relevant email and then choosing not to read it is
Problematic.
Yeah.
So I could entertain 3 months as well.
Should we say 3 months from the documented last day or 3 months from the removal of the ad, which is part of being in compliance? Is
I
removing it.
would feel more comfortable with 3 months from the last documented stay,
Okay.
which would put it at October the 28th. Right.
Why don't I move that we offer relief? Why don't I move that the zoning administrator did not err. Nonetheless, we will offer half off today on the waiting period, allowing the appellant to reapply October 28th.
Second.
Can I see a show of hands? Great.
Oh my goodness.
All right, very good. Mr. Webb, thank you so much for your time today. And as you heard, you are free to reapply come October 28th, and you're going to want to communicate with all these folks when that date arrives. Thanks for your time today. I hope you have a good one.
Thank you.
All right, moving right along.
The last case before the board today is 2024-029. It's 1118 Baptist World Center Drive. Suzanne and Richard Millet. Appellant is present. Is there any opposition? None seen. 5 minutes for the appellant to present his case. This is for advertising and operating prior to obtaining a permit. This is an MUN-A zone district in which multifamily not owner-occupied STRP permits are available. This is governed by BL 2020-187, which requires a 1-year wait period for operating without a permit. The board has discretion under BL 2023-136. On July 16th of 2021, the previous owner, Spiro Konstantinos, obtained a multifamily not owner-occupied STRP permit. The permit was renewed in 2022 and 2023. Over the time of the previous ownership, this property, there were 6 different advertisements posted, the last of which was removed on October 26th of 2023, just short of 1 month after the property was sold. On September 29th, 2023, the appellants, Susan and Richard Millet, acquired the 1118 Baptist World Center Drive. On December 25th of 2023, the appellant posted a new Airbnb ad for the property. There was 1 documented stay in January of 2024, 3 in February, 5 in March, 3 in April, and 2 in May. May 17th of 2024, the 60-day email reminder to renew the permit was generated but failed. The system will not send the email if there has been a change in ownership. The email went into the not sent folder. This was followed up on, and the ownership change was discovered. On May 20th of 2024, the permit was canceled due to the ownership change. Until this date, 5/20/24, the permit status was marked as issued in the system. Therefore, Metro's compliance contractor, Granicus Host Compliance, identified the property as having a valid permit. On June 28th of 2024, the property address was on the monthly list provided by Granicus Host Compliance for advertising and operating without a permit. Inspector John Phelps followed up on the property. He confirmed that the ad was posted and a notice of violation was sent. On July 16th of 2024, the website advertisement remained posted, and Inspector Phelps made a site visit to the property and posted a stop work order, which he documented with photographs. On August 9th of 2024, the appellant emailed Inspector Phelps. She explained that since she was, that this was to be a not owner-occupied STRP, and given that the appellants live in Massachusetts, that they contracted with a property management company to obtain the necessary permits and operate the property on their behalf. She explained that they were operating under the assumption that a valid permit had been obtained. Ms. Millet changed the website advertisement to a minimum of 30-night stay. On August 9th of 2024, the appeal was filed. On September 19th of 2024, as of this writing, there have been 20 total documented stays. The complete list of documented stays is included in your case summary. There were no documented complaints for the property on either the short-term rental hotline or the hub Nashville.
All right. Anyone have questions for staff before we hear from the appellant? It does not sound like it. All righty. Ms. Millet? Or Mr. Millet? I'm sorry, am I butchering your name?
Hi, my name is Kyle Murphy. I live at 23,000 Brush Line Court in Bend, Oregon. I'm here on behalf of the Millets because they're not able to appear.
Okay.
Yeah.
Terrific. So thank you for your name, your address, that we needed both those things. Could you share with us your relationship with them, how it is that you've come to represent them?
Yeah, so I work for the property management company that erred in the situation.
Okay. Turnkey?
Home Team Vacation Rentals. Turnkey is the service that they
Got it.
acquired, yeah.
Terrific. Go for it. Sorry to interrupt you.
Yeah, so there's no dispute in anything in the record. It's all completely accurate. Unfortunately, we had an employee that did not follow through on what they told the Millettes they were doing and what they told our company what they were doing. This came to our attention in early August, and then we went through we tried to do the proper channels to correct the situation. So, the employee tried to correct it on their own. And as soon as we became aware of it, we spoke with the Millettes and tried to go through the proper channels to rectify it. And obviously, we became aware that we were not operating within the guidelines of Nashville and try to do everything we could to correct it. So the property is now listed as a 30-night minimum. There is a multi-month occupant in there. And this is no fault of the Millettes other than not verifying that what they were told was done. So I'm asking to provide some grace to the Millettes in any way that is possible.
So I just want to clarify. So your company is Home Team?
Correct.
And Home Team contracts with a local group?
Yep. Yeah, we have local partners here who manage 412 Hollywood Drive in Old Hickory.
I'm sorry, they manage what?
That's where they operate out of.
Oh, where they operate? I
That's our
apologize.
local.
Okay, I misunderstood. Okay.
Yeah, they take care of cleaning the property. They take care of responding to any after hours complaints. They take care of maintenance, just general upkeep of the property, and they're a partner of ours.
And they are responsible for obtaining permits on behalf of the owners?
Yes.
Okay. And
We work with them on that, yes.
and they know this, right? Because this is what they do full time for
Correct.
a career.
Correct. The individual is no longer employed and no longer working in
Probably for the best.
short-term vacation rentals.
Okay, super. Anyone else have any questions?
Yes. I believe you just said in your statement that when you all became aware that there was a problem in August, so were you not aware of there being both a stop work order and a notice of violation issued prior to that?
Correct. Me personally, yes. The individual who I'm speaking of was aware.
Okay.
And went through, I believe they tried to apply for a new permit. And they went through what they thought they might be able to rectify the situation with.
Okay. And so tell us how it happened that, because you guys were sort of hired from the outset as soon as it was decided that there wanted to be an SDR. Tell us how it happened that there was no communication with the Millettes, that there was a permit requirement and that would be taken care of, and then steps taken to verify that it had happened already.
Yes, so the individual was aware that there's a permit requirement and has got that permit for 2 other locations in Nashville. They just didn't follow through on it. I can't speak to if it was intentional or they just forgot about it and hoped they wouldn't get caught or it wouldn't come up or kick the can down the road. But they were very aware.
And does Home Team not have policies and procedures in place to verify that these things have happened, since it puts the people with whom you contract at substantial legal risk in the event something goes wrong?
At that time, they were insufficient. They have been rectified, particularly because of the situation.
Got it.
Any other questions? No? No? All right. We are going to close the public hearing. We're going to discuss this amongst ourselves and come to a conclusion. So thanks so much. Appreciate your time.
So, yeah, this is another oversight case. where there was some action taken to try to address the issue, the conversion of the listing to a 30-day rental. I mean, just in terms of like, is relief appropriate and what degree of relief is appropriate? In the previous case this afternoon, we had a realtor who lives in another county who had made an error. And those folks ended up with about a 7.5-month wait after the relief that we gave them. Here we have an error by short-term rental professionals that led to this. I'm inclined to be a little bit less lenient when errors are made by short-term rental professionals. I mean, these are folks that market themselves and engage in the business of operating short-term rentals for folks that live here and folks that live out of state, such as this individual. So I don't know what the right, if we choose to grant any relief, I don't know what the right number is, but I did want to just elevate that we had a case already today that landed at 7.5 months that I thought maybe had a more compelling case for leniency than this one. So I'd like to be somewhat consistent, but I'll listen to what other folks think about this, what might be appropriate.
So to my mind, this is tantamount to professional malpractice on two levels, both with the local agent that was associated to handle these things and also with Home Team. And unfortunately, their clients are the victims of sort of their nonfeasance. I am not inclined to offer very much relief. There were 20 documented stays during a period where it was known at two levels that there was a permit requirement. It was not verified that a permit had been issued to cover these stays. And there were policies and procedures not in place or not sufficiently in place, as we just heard, to sort of verify that all things that needed to be in place were in place. I'm not particularly swayed to grant much, if any, relief.
One differentiating factor too between the case we talked about previously today is, if I recall correctly, that was in a building that was only short-term rentals.
Right. Yeah.
Which, I think that that's a worthy consideration in everything that we considered in that case. But, we've had several cases that have come before us where a property management company has made a mistake. And we always treat those differently than someone who's not utilizing property management, who, just has their Airbnb, their home that they're renting out. They're supposed to be the experts. This is a malpractice situation on their end. It's unfortunate for the Millettes, as you described, Mr. Bond, as the victims of this, but I'm not inclined to grant relief in this case.
Mike, what do you think?
I'm still not sure. I don't know. I agree that professionals should be more professional about what they're professing. But also, I find it difficult to penalize the homeowner, which I know will ultimately penalize the homeowner. Now, whether they resolve that out of this, scenario is their decision. But I don't really know. I still haven't made up my mind yet.
That's kind of where I am, that it is obviously the responsibility, and it was shirked horribly by two groups, but the Millettes were relying on that to their detriment. And I do feel some sense of sympathy for their situation.
I do too. And the law neither requires nor penalizes an enterprising permit applicant from retaining the services of someone who is expert in these things and who is more local to the situation than they are. Unfortunately, with that comes a degree of risk. If you completely throw it over the fence and allow them to take over the process without verifying yourself, and I understand that they, it's documented, they ask questions, but I guess for me, I would and not that my own opinions and subjective analyses should carry the day, but I think it is reasonable to assume that one would go, because the permit's going to be issued to them personally, the Millettes, not to the company that assisted you in obtaining the permit. If I never had a copy of a permit in hand, or a permit itself in hand, that would cause me to ask questions. So there were the lesser diligence failure was the Millettes, the larger was the companies, but I still think it's a failure to me that militates against offering any sort of relief.
I'm sorry.
Well, I was going to make a suggestion about a way forward, but if there's more discussion, then I'm happy to listen to discussion before making a suggestion.
I just wanted to say that I don't place blame with the Millettes in this situation solely because, they hired what is a multi-state company to manage this.
Sure.
This is not just a small property management group.
Yeah,
This is a
absolutely.
multi-state outfit. I mean, I
Absolutely.
think that you look and you do your research and you find somebody that you think is an expert, and I think they're able to rely on that. So I don't place blame on them. I do place blame solely on the property management company, which is the unfortunate ramification for the Millettes.
Right.
So if I may ask, legal counsel, we need, to dispose of this case, we need a successful motion. So a motion, if one motion failed, we could make a second motion. Is that correct?
Yes, so you need to have a majority of those present to vote in favor of the motion.
Okay. So, I mean, I'm the kind of unfortunate situation that the Millettes find themselves in is the only reason that I would consider any relief in this case. And I've made it clear that I think it, just to be in line with what we do, if there were any relief offered, it should be substantially more than 7.5 months, which is what the previous case today got. I'm also hearing from members that there may not be interest in offering any relief. So what I would propose to do is present a motion for a vote to offer a 10-month waiting period. And if that fails, then I will vote with the succeeding motion to offer no relief. Well, that's what I anticipate the succeeding motion would be. Does that sound like it's worth trying?
Absolutely. Sure. It's definitely worth trying. Can I ask what date you would affix to the?
Thank you for doing that, yes. The standard we used earlier today
Was the last documented stay.
last documented stay.
Yep.
Let's see here.
I know that we know of 2 documented stays in May. We know of no documented stays for June or July. Is that correct? I know there was a stop work order in July.
Could we go to staff to,
Yeah.
where's the,
Mr. McBroom's looking that up right now.
thank you.
Last documented stays, there were 2 in May.
Okay.
So I would like to go from June 1st, if that's the case, because we don't get accurate data from Airbnb. We just have approximate.
So 10 months from June 1st, which
May,
would be
April.
April. Wow.
We're not good at this.
April of 2025 would be the
April
eligibility
1st.
date. New eligibility date.
Tee it up, Sean.
All right, so I'll move that the appellant is offered limited relief and eligible to reapply for a permit April 1st of 2025.
Second. Can I see a show of hands? Who supports that?
And the zoning administrator?
Oh, I'm sorry. And let's back that up. We want to move that the zoning administrator did not err.
Yeah, I'll amend that motion to include the fact that we do not believe the zoning administrator erred in their determination.
Okay. I still second. And let's see a show of hands if you're willing to offer 10 months of relief. Hey,
No, 2 months of relief.
I'm sorry?
It's a 10-month wait period.
10-month wait period,
instead of
2
the
months of
12-month.
relief. Yes. We're all in agreement?
Mm-hmm.
Very good. Okay. So is it Murphy, Mr. Murphy? Mr. Murphy, so the appellants the Millettes will be eligible to reapply come April 1st of 2025. So it is a little bit of relief, but relief nonetheless.
It's a 2-month reduction.
Yeah. So thank you so much for your time today. We appreciate it. And before we close the hearing out, big thanks to Whitney Kimmerling for serving for all these years. We're gonna miss you. We'll get her back. All right.
Yeah. Right,
No. Let's close the hearing before we get a speech. Our hearing for today is closed.
So how does this work? Is this next meeting?
No, there's a new
candidate. Is the person that you recently appointed to replace you, or was that to replace? First 2 months.
Should we wear black drapes?
It's not personal. It's good morning.
Wow.
There may be placards, I don't know.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.